been established for nearly 100 years as a pillar of government, interpreter of laws, arbiter of disputes. In 1872, with a case known as Taylor versus Taintor, the court validates the arrest powers of the bondsman and the bounty hunter.
The bail have their principal on a string, and may pull the string whenever they please.
It's a ruling that has endured.
Taylor versus Taintor has lasted so long because it's legal, it's authoritative, and it's right.
For the door, now!
One might think that given the importance of Taylor versus Taintor to bondsmen today, that the case revolved around the force used to take a principal into custody. But it didn't.
The court's opinion is written by 68-year-old Justice Noah Swain, an Ohio prosecutor appointed to the high bench by President Abraham Lincoln in 1862. Swain begins with the facts, telling the story of a bondsman who sued the county of Fairfield, Connecticut, for the refund of an $8,000 bond he had been forced to lose.
A man named McGuire was arrested and charged with a crime in Connecticut, and a bail bondsman named Taylor wrote a bail bond so that he could be released from jail.
When Edward McGuire signs his bail contract in Connecticut, there is one thing he never tells bondsman William Taylor. McGuire is a wanted man, charged with burglary in the state of Maine. Taylor accepts his client's 10% fee and allows him to return to his family home in New York, with a promise to be back in Fairfield County for his Connecticut trial. Justice Swain tells Taylor this is a big mistake for all bondsmen.
They may doubtless permit him to go beyond the limits of the state within which he is to answer, but it is unwise and imprudent to do so.
And so, 3 different states are involved in the case that would make such history. Once McGuire is in New York, the state of Maine issues an extradition request. New York police arrest McGuire, send him back to Maine, and put him in jail. He is unable to appear in the Connecticut court and causes William Taylor to forfeit his bond.
The bondsmen were upset about that, and so they sued. And they said this was an operation of law that made our ability to present him in court impossible. And as a result, we should get our money back.
The Supreme Court first takes the case to decide the dispute over money, confirming the bondsman's obligation to keep a tight rein on the suspect.
Whenever they choose to do so, they may seize him and deliver him up. They may imprison him. They may exercise their rights in person or by agent.
In the course of the opinion, Justice Swain chose to add an extra comment on the powers of bail bondsmen that had nothing to do with the facts of this case.
They may pursue him into another state, may arrest him on the Sabbath, and if necessary, may break and enter his house for that purpose.
It was gratuitous, but it's come to be probably the most important part of that case.
By adding his extra comments, Justice Swain puts the High Court's approval on the powers that bail agents and bounty hunters have held under common law for centuries. The ability to break into a suspect's house or pursue him across state lines allows the bounty hunter to return suspects for trial, helping to assure the function of courts nationwide.
And that's done without taxpayer expense, which was very important to courts. The incentive is to have the defendant before the court. Above all, and if financial reasons the way to do it, then why mess with a good thing?
Many states will do anything to get fugitives back. Many states know that to get a fugitive back, they are hindered by constitutional provisions, the right of extradition. They know bail bond agents can get these people back in a heartbeat because of Taylor versus Taintor.